Hello everybody, good evening. My name is Martin Salvo and welcome to a live Partner Visa Q&A. Ordinarily I do these streams inside our private Facebook group Partner Visa Secrets, but we're actually trialing a new system this evening, and you might be joining us from different locations, different pages. You might join us from our public Salvo Migration Facebook page. You might see this stream on our YouTube channel. So we're trialing a new method, but it should allow more people to join the streams and ask more questions. But simply put, if you've never attended one of these sessions before, I'm here to answer your partner visa questions. I'm a registered migration agent, senior immigration lawyer at Salvo Migration. And effectively, that's what I do here on these evenings for about an hour. I welcome people to ask their questions in the stream, and then I'll work through the questions as they come in, as they pop up, in order in which they are asked. If we work through all the questions that are asked during the stream, I'll then go back into our Facebook group where members ask their questions on a daily basis. And our team here at Salvo Migration do answer members' questions as frequently as possible. But I'll go back through the group and I'll see if there's any questions that haven't been answered, and I'll answer them verbally. So I'll give it a few more minutes for people to join the stream. Hello Tuluwani. If you have a question, you're more than welcome to ask. So just type it in the chat, in the comment section, and I'll get to it as quickly as I can. So feel free to ask. What I might do in the meantime, guys, whilst we're waiting for people to start asking questions, for those of you that don't know who I am, my name is Martin Salvo, registered migration agent, senior immigration lawyer, author. I've written a couple of books that help people with partner visa documentation, such as how to write their relationship statement, which is a very important document. Arguably, I would say the most important document in any partner visa application. I have fancy legal qualifications. I did do a law degree, a Bachelor of International Business, and a few other things that allow me to be a lawyer. I'm a husband, a father of an 18-month-old daughter now. That slide is a little bit outdated. My family migrated from South America a while ago. I used to play soccer once upon a time, but my mid-30 age bracket has forced me to stop playing, unfortunately. I did try to play again, revive my soccer career a while ago, but my back stopped that in its tracks. And I do like technology. I'm a bit of a nerd, a bit of a geek at heart, and hence why you probably see these types of streams or our content. That's effectively where it comes from. So that's a bit about me. I can see a couple of questions have come through, so I'll get straight into them, guys, because otherwise we could be here all night, which, look, I have no problems necessarily, but I know a lot of you have busy lives and probably have other things to get to. So I've got a question here from Facebook user. Now, look, I can't say why sometimes it doesn't put forward the person's profile. Sometimes it does, sometimes it doesn't. It's a bit of a tech issue. I'll see if I can fix that for next week's stream. But I have a question for you. My partner visa application that are subject to Schedule 3. How long does it take for immigration to ask for an evidence of a compelling reason? It's been waiting a year now and I haven't heard reasons. I haven't heard from them, although I have added some compassionate evidence, being my partner has some sickness. Mr. or Mrs. Facebook user, I suppose that answer has to be answered in a pre-COVID environment and a current COVID environment. In a pre-COVID environment, we would expect the department to pull aside any cases that had Schedule 3 waiver of requirements within a few months. So within 3 to 6 months from an application being submitted, if that case was subject to Schedule 3, and for those of you at home that don't know what Schedule 3 is, it means that if you're applying for a partner visa from inside the country and you don't hold a substantive visa, or you're on a bridging visa, let's say you've had a visa refused and you're waiting for an appeal of another visa and you are looking to apply for a partner visa, you're not on a substantive visa, you are on a bridging visa. Similarly, if you've had a visa before and it's been cancelled, you've appealed that decision and you're in Australia on a bridging visa waiting for that appeal, or if you're just unlawful, illegally in the country, either of those scenarios will require an applicant for a partner visa to meet Schedule 3 criteria, which in simple language means that you need to be able to show compelling and compassionate circumstances. So this question is asking me, how quickly after lodgement does the department ask you to show compelling and compassionate circumstances. And like I said, before COVID, we would expect that to happen very quickly, within a few months, because the department would ordinarily want those people to show compelling and compassionate circumstances immediately. And then if you did, they would put it back in the queue. They wouldn't let people just enjoy the benefit of waiting for a long period of time only to then refuse them under Schedule 3 in future. So they were previously asking people, couples, to show compelling and compassionate circumstances quickly after lodgement. However, I'm not surprised to hear that you haven't heard from them from a while. You've mentioned 12 months. The reality is that COVID has impacted all partner visa processing procedures with the department. Even the simplest of things is taking a very long time. Partner visa decisions have really slowed down. Even if you receive requests for information, simple requests for information for partner visas, such as medicals and police clearances, there's no complications. Couples will organize the medicals, organize their police clearances, provide them to the department. They're still waiting months and months and months for the finalization of those applications, even though everything else should be ready to go. So I'm not surprised to hear that you've been waiting a long time. Unfortunately, there's no way for me to say exactly how much longer you're going to be waiting. My advice in any similar situation is just to make sure you continue to provide them more documentation. You effectively have all the way until they make a decision to show you have compelling and compassionate circumstances. So if anything happens from now until the decision, you make sure you evidence that to the department. All the best, good luck. I hope you get a positive decision quickly. Next question, Toluwani. Please, I want to know if I go for a partnership visa, what are the basic requirements? My partner is on Centrelink. Toluwani, I suppose to really simplify partner visa requirements, you need to be either the spouse of an Australian citizen, permanent resident, or de facto partner of an Australian citizen or permanent resident. Now that's a very simple definition, and I mean that you have to be more than boyfriend, girlfriend, boyfriend, boyfriend, or girlfriend, girlfriend. Serious committed relationships can be eligible for partner visas. However, if you would like a complete breakdown and explanation of what those words mean, what it means to be spouse, what it means to be de facto, somewhere around this stream there should be a link to our Partner Visa Secrets workshop. Effectively, that's a 2-3 hour online class where I'll sit there and I'll teach you everything that I know, that I've learned over 10 years of preparing hundreds of successful partner visas. In those sessions, I'll teach you what it means to be de facto, what it means to be spouse, and what it takes to get your Australian partner visa approved. It's a free class. There's a registration button somewhere around this link. Please save your seat. I promise you it's worth attending. And it's free, so you have nothing to lose. Next question. Hey Martin, I've applied second time for my wife's visit visa. 309 is application in process. They refused the first one on GT exactly one day after I applied. Now it's been 2 weeks. I haven't heard anything about the second visitor visa. If they refuse, should I apply for family sponsored? Please advise. Look, I would be curious to know if you have provided or have applied for a travel exemption as well. We hear that visitor visa applications may just kind of process indefinitely if you don't have a travel exemption also submitted, because they can't approve one and not the other in order for that person to enter Australia. So that would be my first question and first piece of advice, is make sure you also submit a travel exemption. That might speed up the decision-making process. In terms of should you then apply for a family-sponsored visa as a third attempt, look, there's no harm in trying. The fact that you already have a pending offshore partner visa suggests to me that applying for a family-sponsored visitor visa probably makes the most sense anyway. In cases where couples have an intention to come onshore and apply for an onshore partner visa, we would say do not apply under the family-sponsored stream, because it has a mandatory no further stay condition. It means you can't apply for the partner visa onshore unless you get that waived, which is discretionary and subjective and you can never really predict. But the point is that if you apply under the family-sponsored stream, the no further stay condition is mandatory. Whereas if you apply under the general tourist stream, it's discretionary. So at least there's that possibility that you won't get the no further stay. So then you come in and you apply for the onshore partner visa. However, if you already have a pending offshore partner visa, I would presume that there's no intention to come in and apply for an onshore partner visa unless you want to spend more in government fees, which is doable. You can apply for more than one partner visa. Just keep that in mind. Maybe yes, if you do, get the second decision refused, attempting a third time under the family sponsored stream, there's no harm. I mean, realistically, it's not going to have a negative effect on the partner visa. It's arguable that a family sponsored visa has a higher likelihood of approval because they can request a financial bond from the Australian sponsor, which maybe alleviates any concern they have about the person coming here and staying illegally. But let me just say that, you know, tourist visas at the best of times are very, very unpredictable, but particularly now with COVID, you know, the GT requirement is notoriously subjective. You know, sometimes, unfortunately, there just isn't a way around those negative decisions. Sometimes, you know, the department just don't want to approve visitor visas to certain types of people, and sometimes it just requires waiting until the partner visa is approved for that couple to be reunited, unfortunately. However, there's no harm in retrying. So if you don't get the second decision approved, certainly try a third one under family sponsored stream, and, you know, good luck, all the best. Next question. Toluwani, in which, so I assume this is a flow on from the last question, in which she's got to leave Centrelink and also about get a job. I have gone in partnership pack for a while now by trying to gather all that's needed for this. Okay, so Toluwani, if your partner receives Centrelink, and this is something I will talk about in the workshop, okay, so I do talk about the importance and the significance of Centrelink, but just to quickly say, if you're applying for an onshore partner visa or an offshore partner visa and the Australian sponsor receives Centrelink, it's very important that the relationship is declared with Centrelink, because if you are trying to obtain a partner visa under the grounds of being in a de facto relationship on the one hand, but on the other hand, you're not declaring that same relationship to the government department, the government's going to say, well, which is it? Are you in a de facto relationship or are you not in a de facto relationship? It can't be both for your benefit. We can't say yes to you being de facto and give you a partner visa whilst ignoring that and still continuing to pay you money or pay the sponsor money on the grounds of them being single. So that can often be a very critical point, and, you know, you will see and hear of partner visas refused purely based on that. So it's very important that the Australian sponsor notifies Centrelink of the relationship, preferably as soon as possible, and certainly before an application is submitted. But in terms of everything else that you need to submit a partner visa, please register and attend the workshop. There's a link around this video. Next question. Facebook user. Hi Martin, good morning. Good morning from the cold, rainy UK. We're in the opposite over here. We're in the warm and humid and bright Queensland, Brisbane, Queensland. My question today are, do we have to provide pregnancy evidence once the baby is born? He's 18 months old now. Also, as we are married in Spain, we have a family book, which is an official document there where the marriage and children are registered. Of course, I have already collected marriage certificates and the relevant child's documents. Just wasn't sure if it's worth adding that one too, as I assume it would have to be translated. Thanks a lot again for all your help. In terms of the birth of the child, look, it's always worth evidencing the birth of a child of the relationship. I mean, not only does that increase the likelihood of the partner visa being approved, however, it may also affect processing times. It may speed up processing times. In my experience, you know, strong couples with children tend to have their applications processed much faster because they're a lot lower risk. You know, the government can be generally satisfied that the relationship is genuine and continuing and exclusive and all the things that are required for a partner visa, you know, because there's children associated. That's not always the case, but certainly evidencing the child's birth can only be in your favor. It can only be a positive fact and, you know, only increase the likelihood of an approval and hopefully a quick approval. In terms of getting those documents translated, look, I understand there's always a bit of a balancing act in terms of getting documentation from overseas translated because they are, of course, another expense. But there's certain things that should be translated because they are impactful. Anything relating to the birth of a child, please get translated. And the family book, you know, if the family book has the, you know, all the parties listed, the applicant, the sponsor, and the children, that's also a very powerful document. So I would encourage you to get at least those items translated. And then you can be a little bit more selective in terms of what else you get translated that might be in Spanish. I hope that helps. Facebook user, anonymous. Hi, if a 309 visa application is refused, what is the appeals process, the length of time to appeal, and the cost to appeal? Thanks. The length of time to appeal any partner visa at the moment, last time I looked, is probably at least 2 years. So the tribunal, the AAT, will have its own processing time. If you would like to see today's up-to-date processing averages, just go to Google and type in AAT waiting times, AAT appeal processing times, something along those lines. You'll find the link and you'll see there the average, the median waiting length or processing length for partner visa appeals. And last time I looked, it's probably around 2 years. In terms of the cost of appeal, from memory, the appeal fee is $1,800, give or take, 1,800 and a few cents, okay? That's to appeal. Then the appeal process from there is you have that entire period that you're waiting for a member to assess the file, to pick up the file. So you have that whole time period to continue to forward more relationship documentation and evidence to the tribunal. Ideally, you want to be addressing whatever the reasons were for refusal by the department to make sure by the time the member picks up the file, not only do they have everything that was given to the department that gets forwarded to the tribunal, but also anything that's happened in the relationship since the refusal by the department till they open the file. Because what might happen is if that's well evidenced, if the reasons for refusal were trivial and you're able to counteract that in your additional documentation, you may win the appeal without needing a physical hearing. It's called a decision on the papers, which means that the tribunal say, yes, we accept this relationship, it does meet the requirements, we're going to remit it back to the department, we're not going to waste time on a hearing, we're too busy, this seems fine, I'm just going to remit it back. So that's generally the process, the cost, and the time frame. Toluwani, just want to know basically what's needed as we plan to apply in March 2021. Toluwani, I hate to sound like a broken record, but in all honesty, you will know what's needed by attending the workshop, okay? But just to simplify, you need to be able to show that you're cohabitating, that you're pooling your finances, that your social circle, your friends and family are aware about your relationship, and you can prove that they are aware, that you provide supporting documentation from them, and that the nature of your commitment is more than boyfriend-girlfriend. That's very simplified, but it's broken down in the workshop. Please do register. Next question. Hi Martin, I hope you're well and everyone at your great team are doing good. I will be submitting the 801 in a week, and my question for today is whether I should upload relationship evidence in separate files or should I just combine them in 5 to 6 documents similar to what we used when we did updating our evidence for the 820. And Martin, please keep in the tie, mate. My wife says it looks good on you. My regards, all the beautiful people. Thanks, guys. Look, in terms of how you organize your documentation for the 801, look, I suppose the best way to put it is that for the 801, what they're worried about is that you're still together, okay? The assessment of the relationship really happened in the first instance, when the first decision was made, when the 820, the temporary partner visa, was decided. That's always the biggest hurdle because it's the first time the department is assessing the relationship. By the time they get to the 801, especially if it's only been a very short period since the approval of the 820, they know that the relationship is genuine because they already decided that recently. It's just about showing that you're still doing those things. You're still cohabitating, you're still pooling your finances, you're still living together, you are still a couple. So you don't need to be as calculated with your documentation. I don't think there's any problem in uploading them to the department systems. You still want to collate things that are similar. You still want to rename documents in a way that brings the case officer's attention to what that document is. But you just don't need to go in as much depth as what you would have for the 820, okay? But you certainly want to evidence the relationship, but don't stress too much, okay? Unless there's just a critical issue, and really unless there's a breakdown of the relationship, there should be no reason why you aren't approved the 801. And I will wear the tie next week. Next question. My daughter is turning 15, is she able to write a reference letter supporting our relationship to attach our PMV 300? As she's underage to do the Form 888, what would be recommended or not necessary? Look, there's no issue with your daughter writing a signed statement. Okay, it doesn't need to necessarily be a Form 888. All a Form 888 is a templated statutory declaration form. Okay, so the Department of Home Affairs, the Australian government, they give us this template and they say, give these templates to people that need to write statements about a relationship, because it asks certain questions. It asks, how do you know the applicant? How do you know the sponsor? Why do you feel the relationship is real? What else would you like to tell us about the relationship? However, all it is a stat deck. So, you don't have to use Form 888s. This doesn't necessarily just apply to people under 18. This applies to anyone in Australia or overseas. You don't have to use Form 888s, okay? You can use statutory declarations in Australia, affidavits. If people are overseas, you can use whatever the equivalent forms are over there. So if there's stat decks in the UK or affidavits in the UK, use those templates. What's important is that the person making the statement answers the same type of questions that are on the Form 888. So with that in mind, there's no problem in your daughter writing her statement, just, on a Word document, typing it up, addressing the questions that you find in the Form 888, signing it, dating it, and treating it as if it was a Form 888, but it just isn't a formal Form 888. So yeah, there's no problems in your daughter providing her supporting statement. Next question. 2 of travel exemptions have been denied. 2 of our travel exemptions have been denied, applied on immediate family member basis, although I have attached a letter from the GP regarding my mental exhaustion and pressure. Should I apply on compassionate, compelling reasons? Thanks. Look, whether you apply under compelling, compassionate circumstances or under the definition of immediate family, the reality is that the decision's very arbitrary, very inconsistent, very subjective, and it may not necessarily make a difference. You would still be attaching the same documentation. So even if you're applying under the grounds of immediate family, you still want to provide evidence of compelling and compassionate circumstances, and conversely the same. If you're applying under the grounds of compassion and compelling reasons, you still want evidence at the same time, because why wouldn't you, that you are the immediate family member of an Australian citizen or permanent resident? So unfortunately, there isn't a silver bullet to the inconsistencies of travel exemptions. It's really a matter of trying a few times and making sure that you continue to try, because I've seen, I've heard, I've read of couples attempting 8, 9, 10 times, and on the 10th time they're finally approved. Thankfully there's no application charge associated to the travel exemptions, and maybe that's why they're so inconsistent, because the department are allocating no resources to those decisions because they're not being paid to. I'm speculating, but you never know. So look, it's worth trying given that there's no fee associated. But unfortunately, I can't say whether or not you changing the grounds for applying for the exemption is going to make any substantial difference, but it's certainly worth trying. All the best. Good luck. Travel exemptions are notoriously unpredictable at the moment. Facebook user. I have to figure out why it's not showing me people's profiles. Hopefully next week I'll be prepared. Once my partner is onshore, can we apply for the bridging visa to extend to stay onshore until we get the decision on the 309, or should we apply for the 820-801? There is a way to apply for a bridging visa if you're waiting for an offshore 309, but that's specifically if when you applied for the 309, that person also held a visitor visa. So it's a very specific circumstance. The person had previously applied for a visitor visa, they held that visitor visa or a visa, they then applied for an offshore 309, they then entered Australia on, let's say, that visitor visa, then they're looking to apply for a bridging visa to keep them in the country lawfully waiting for the offshore 309. So it's, let's say, a loophole or a way around the issue that 309s don't have bridging visas associated to them technically. But if you're in that particular circumstance, there are grounds to get a bridging visa associated. So that is possible depending if you fit within that definition. Alternatively, yes, applying for an onshore partner visa has an automatic right to a bridging visa. It's a bridging visa A. There's no work restrictions, the eligibility for Medicare. So, depending whether or not you tick those boxes, in order to apply under the, let's say, 309 loophole, let's call it, to keep your partner in the country for a long period of time, it might be that applying for an onshore partner visa is an appropriate option, is the best option. But obviously you have to factor in costs because you're effectively paying again. There's no way to transfer the fee you already paid for the 309 for another 820. There's no grounds to get a refund for the offshore 309. Only under very limited circumstances will the government ever issue a refund. So look, I can't advise really specifically. I don't know all the facts, but those are the options depending on what your exact circumstances are. Next question. Is the birth certificate for the sponsor a necessary document? Mine is in another language and not in my possession. Not necessarily, no. I mean, if you can prove the Australian sponsor's citizenship or permanent residence in another way, a birth certificate should not be necessary. You need to be able to prove the identity of the sponsor, prove the citizenship or permanent residence of the sponsor. And look, it's not uncommon for people not to have their birth certificates or have lost their birth certificates. And I've never personally ever seen a partner visa refused because the sponsor didn't have his birth certificate or her birth certificate. Next question. We just applied for a partner visa. Our relationship is registered. Can we get married anytime? Okay, so there is a video on YouTube. It's called the 12-month rule. It's a partner visa secrets episode. And I talk about the issue of, or the potential risk in getting married after lodgement if at the time of application you had a registered relationship. Now, to give you a very crash course summary, the purpose of registering a relationship is that it removes the 12-month rule, okay? And this question tends to pop up at least once a month, but probably more frequently than that. If you're applying on the grounds of de facto, you need to satisfy the 12-month rule, unless you're in a civil union or you have compelling and compassionate circumstances. Let's forget compelling and compassionate. Let's focus on what we're talking about here, is having a civil union. If you then apply, and then whilst you're waiting for the partner visa to be decided, you get married, what that does is it avoids the civil union. You no longer have a civil union because you're now married. However, the problem is that you were not married at the time of application. You were just de facto. So strictly speaking, legally speaking, it's within the rights of a case officer to apply the 12-month rule to that relationship because there's no civil union anymore. And at the time of application, they were de facto, which means at that point in time, the 12-month rule has to apply. However, there is government policy that allows them to approach this very flexibly. And basically they say, we will very likely not approach it that way because we see that that's unfair. If a couple gets married after lodgement, but they were registered pre-lodgement for a civil union, we won't apply the 12-month rule, we promise. Now, our job as lawyers is to focus on what the law says and not necessarily what the government has said they will do. Because the issue is if the partner visa is refused because of this scenario and you go to the tribunal is also only worried with what the law says. And the law means that the 12-month rule should be reapplied. That's strictly what the law is saying. So our advice to our clients and to anyone who asks me this question is not to get married if you have applied under the grounds of a civil union at the time of application, because you're opening it up to risk. You're increasing the risk factor of that case, and unnecessarily, because if you've registered the relationship, you've removed the 12-month rule, and getting married after lodgement doesn't really change what you had at time of application. That's really what they're going to look at anyway. So weighing all that up, we suggest not to get married. Next question. Do you need to declare your relationship with Centrelink if you've applied for a PMV 300? I'm the sponsor on Centrelink. I would recommend declaring the relationship, yes. Next question. Please advise about partner visa sponsor eligibility. That 5-year bracket starts time is the first application lodged or decided. The 5 years starts from the date of lodgement of the last application. So I might go to my trusty whiteboard, okay? So let's say that John is the Australian, sponsors Linda for a partner visa. And they applied for that partner visa on the 1st of January 2013. Now Linda is approved her partner visa. Let's say she gets both the 820 and 801 on the 1st of January 2015. Okay? Unfortunately, John and Linda don't do very well after the visas are granted and the relationship ends. Sometime in 2016, John meets Mary, and maybe somewhere around, I'm running out of screen, but hopefully you can see, somewhere, let's say around, say the 1st of January 2018. Okay, so John's been with Mary for a couple of years and he says, okay, look, I'm willing to sponsor someone else again. I learned my lesson the first time, but I really love Mary and I want to try a second time. So it's now the 1st of January 2018 and they want to apply for a partner visa. Now, it's been more than 5 years since John applied for Linda's visa, so there's no problem. Okay, it's not 5 years from here, it's 5 years from here. However, in fact, it's actually a little bit more lenient than that, because let's say that John and Mary actually apply on the 1st of January 2017, okay? That is within 5 years, right? So that's within the 5-year limitation. However, you can still apply, John and Mary can still apply, as long as the department do not decide the visa before the 1st of January 2018. Sorry guys, you want to be able to see that, but 2018, okay? Basically, they can still apply within the 5-year bar as long as when the case is decided, they're not in the bar, okay? As long as it's past the point, and look, processing times for partner visas are a couple of years, so you can probably safely apply a year or so within the 5-year bar if you absolutely have to, and you might still be okay depending on the time frame. Now, when the proposed changes to partner sponsorships happen next year, late next year from what we understand, that's going to be completely different, okay? So they're going to ask the sponsors to apply for sponsorship approval first. And if a sponsor's within the 5 years since they last applied for their last partner, they're going to be knocked back because they're within the sponsorship bar. So it's, I suppose they're removing a bit of a loophole there where you can still apply for partner visas even if your sponsor's within that 5-year bar, because that by the time the department open your case, they're probably going to be past the 5-year point. But when the changes happen next year, guys, don't stress, it's not tomorrow, it's not next, January, March, it's late next year, that will become more difficult, okay? I hope that answers your question. Gurpreet. Hey man, I applied for my partner visa 4th of February this year. I have a 2-year-old child and my wife is pregnant with a second child 5 months. You think how long my visa will take? I'm on a bridging visa C. Gurpreet, if I had the ability to tell you how long your case was going to take, or if I had the ability to tell people how long their cases were going to take, I could probably make a lot of money out of just charging to tell them that rather than doing partner visas. Because the reality is that no one knows how long a partner visa is going to take, unfortunately. I wish I could tell you. What I can say though is that given that there are 2 children of the relationship, that tells me that, assuming everything else is okay, it's quite a strong case. As long as you're evidencing the birth of the children and evidence the pregnancy to the department, let them know that your wife is pregnant. It might be worth requesting priority processing in this instance and see what happens. You might get a decision sooner on the basis of the children, okay? Because in most instances, Australian biological children, are typically a factor that helps to speed up processing of applications. However, it really does depend on everything, okay? And the factor in the BBC tells me that, you might have had some visa complications on the way, and that's why you're on the BBC. I hope we're not dealing with Schedule 3 issues, but that being said, with a couple of kids, you should be able to get a Schedule 3 waiver, assuming that's even applicable to your case. So, look, Peter, I can't predict, okay, but at least you have some good facts there, and just make sure you're evidencing the kids, like I said, to the department. And I hate to sound so clinical, but make sure you're proving that they're yours and proving that the kids are born, and that might help to speed things up. Next question. I have a baby boy with my partner, traveling with him to meet his dad on Tuesday. I have an exemption to leave, though in process of doing partner visa and visitor visa also, so that he can come to Australia. I might have to reread that because I'm not entirely sure who is who. I have a baby boy with my partner traveling with him to meet his dad on Tuesday. I have an exemption to leave, though in process of doing partner visa and visitor visa. Also, he can come to Australia. I'm very sorry, I'm not entirely sure what the question is. Please feel free to reword the question, and I'll try to get to it before we end the stream tonight at 8 p.m. Brisbane time. Is the birth certificate of the Australian sponsor required? What if it's not easy to obtain in another language? Similar question to before. It's not necessarily compulsory as long as you can prove the identity of the sponsor in another way, such as passport. You should be able to avoid the need of providing a birth certificate. Next question. Hello there. My partner was on Centrelink for a while. Then we became de facto. We haven't notified Centrelink. We will definitely do it, but we're concerned it might be a problem that he was on Centrelink as single when he actually was in a de facto after he claimed Centrelink. Will this be a problem for our application? I suppose I can't comment in terms of implications to Centrelink. Okay, I can't advise regarding if you notify Centrelink now that the relationship had started previously, if that is implications to Centrelink payments or having to back pay. I'm sorry, that's just not our area. But in terms of implications for the partner visa, no, not necessarily, but you do need to be tactful and careful in the dates that you're claiming, okay? So if you're claiming that the relationship as part of your partner visa application commenced whilst your partner was still receiving Centrelink, and the Australian government and the Department of Home Affairs find out, or they're able to discover that your partner was on Centrelink during that period, that could be a reason for them to question the relationship further. Okay, it's not necessarily automatic grounds to refuse a partner visa, but it's certainly something that could be scrutinized. Okay, so I think you have to approach it one step at a time. I think you have to contact Centrelink, have a conversation with them with regards to implications of backdating the relationship to when it legitimately and genuinely commenced, because that's always going to be better for you when the time comes to apply for the partner visa, because then you can claim those dates for the partner visa as long as it's consistent with what Centrelink has. It's when data is inconsistent that it can cause problems, and we know that the Department of Home Affairs communicate with Centrelink, communicate with the ATO, cross data sharing across government departments. So it would be naive to say that there's no way they're ever going to find out, and that's just not true. So look, you do have to approach it carefully. I would have a conversation with Centrelink first. Mambo, does the sponsor, Australian by conferral, need to obtain a police clearance from the country of origin even when she hasn't lived there for more than 12 months in the past 10 years? If they haven't been there for more than 12 months in the last 10 years, it's unlikely that they will be requested to provide a police clearance from that country. I can't say definitively because sometimes case officers, you can never predict what a case officer is going to request. However, if the person hasn't been there for the last 10 years, typically that's enough for them not to request one. Next question. Hi Martin, we have money transfers we've made to each other over WeChat and Alipay as our evidence of shared finances. Both apps are in Chinese, so the screenshots we got from there are in Chinese too. Our names are shown in English. Transfers are shown as amount of money or amount of money, but the word months and day in the date are words from, to, are shown in Chinese. Should it all be translated when we apply, and can we translate it by ourselves, or we have to pay somebody to translate those 2 years of transfers for us? Look, in terms of the expense of getting things translated, you have to strike a balance, because do you have to get everything translated? No, not necessarily. However, the onus is on you to make the case officer's job as easy as possible. Now I'm assuming you're applying for an onshore partner visa. You have case officers based here in Australia that don't speak Chinese ordinarily, or don't speak Mandarin, and you're trying to provide them documentation that has in some sense, it's loosely connected to the applicant and sponsor because it has your names, but that's about it. And there's some figures there. There's obviously a lot of words that aren't in English. If I were a case officer that received that, I would, I'd take it into consideration, but I'd also be unsure on what everything else was being said in those documents. So, in a world where money wasn't a factor, yes, I would suggest get those types of things translated. In terms of can you translate them? No, they have to be officially translated. So we recommend getting translated from NATI accredited translators, and yes, there are costs associated. But like I said, no one particular document is mandatory. Okay, so it's really a question for the couple to decide how much they want to invest in this process, how cautious they want to be, and how easy they want to make the case officer's job. Okay, how organized do you want to be? How easy do you want to make the case officer's job? In a world where where money wasn't a factor, like I said, you would just get everything translated. But obviously, we're talking about what sounds like a very large translation project, given there's so many pages. So it's up to you guys to decide. I'm not going to tell you that you must. Would it be better to? Yes. Okay. So, you do what you want with that info, and ultimately the decision is yours as a couple, factoring in what you can afford. What is the bar level to apply to leave for Australia for 90 days or more? I just want to get to Thailand to marry my partner. Busy, we don't deal with travel exemption applications for Australians to depart the country. However, obviously, it does pop up a lot in our day-to-day. And the general consensus is that if you're leaving for more than 90 days, or at least you're claiming that you're going to leave for more than days, and you can prove you have airfares that don't return for less than 90 days, those applications tend to be approved, okay? But not always. It's also a bit of a coin flip. So it's worth trying. And if you get approved, it opens up the door for you to go and marry your partner. But just keep in mind, though, that you going and marrying your partner doesn't mean that your partner is going to be able to get a travel exemption themselves to come to Australia, okay? So even married couples are being knocked back for travel exemptions. Particularly couples that get married during the COVID period. If couples were married before COVID, or in strong de facto relationships before COVID, those cases seem to have a higher degree of approval, higher level or chance of approval, versus couples that are now getting married or now trying to strengthen their facts because the government can see that it's happening for the purposes of a travel exemption. So, look, I'm just giving you all the info so that you can make that decision whether or not it's worth going or not. You have to factor in the cost of the airfares to come back in, the cost of quarantine, of course. So a few things there, Busy, but I hope that helps. Citrix Matrix. That's a cool name. Hi, can you please tell me your phone number? Please, I'd like to play. You can contact us on our website, salvomigration.com.au. You'll find our contact number there. However, online inquiries are the best way to communicate with us because it allows you to explain your relationship facts in your inquiry. We can get a good understanding of what your facts are, and then we can help from there. Next question. My question, what is the chances of him being accepted with visitor visa and exemption while I'm over there? How long is the process? I can't give you a statistical answer in terms of what the chances are. I'm very sorry. They're just too inconsistent for me to give you that opinion. All I can say to couples is that it's worth trying to get these travel exemptions because it opens up the possibility to come in and apply for an onshore partner visa and then just stay here whilst you wait for the onshore application. But I can't say the likelihood of any couple necessarily. Couples that we speak to regarding travel exemptions, we're very honest, we're very transparent around the inconsistencies and the likelihood of success and refusal that we can't predict, but that we'll try. We'll continue to try as many times as we can until either we get an approval or the couple decides to wait. Decides to wait until the borders open and then maybe try then, or the Australian partner decides to go to the partner over there and spend time there, and then maybe apply for travel exemptions in future if we still need to apply for travel exemptions. So unfortunately, I can't answer that question. I'm very sorry, but I wish you all the best and just keep trying. Okay, I'm just working through the questions, guys. There's a few tonight, so I'm just trying to be fair and make sure that I get to as many people as I can. What are the odds of landing a BV if the case is I'm a student visa, not seeking student visa cancellation, and applying for a partner visa in May? My student visa ends on June. I'm just going to read that again. What are the odds of landing a BVE if the case is I'm a student, not seeking student visa cancellation, and applying for a partner on May? My student visa expires on June. As long as you apply for the partner visa before your current student visa expires naturally, you will get a bridging visa A for Apple, not a BVE, a BVA. If your student visa is cancelled before you apply for a partner visa, then yes, student visa is cancelled, you apply for the partner visa, then you get a bridging visa E. If the student visa is cancelled after you apply for the partner visa, so let's say you apply for the partner visa in May and they cancel your student visa, okay, immediately after, which is very unlikely, but let's say that it happens. You apply for the partner visa, they cancel your student visa, so it didn't expire, it just was cancelled, then you get a BVE, okay? There's no, it's not discretionary, you're legally entitled to a BVE, okay? I've never ever personally heard of someone not get a BVE if they've had a visa cancelled and applied for a partner visa, or applied for a partner visa and then had their student visa cancelled, whichever order may have happened. So what are the odds of getting a BVE? High. What are the odds of getting a BVA? As long as you apply for the partner visa before the student visa expires and then you don't get the student visa cancelled? High, okay? BVAs are automatic. Next question. Sorry, following on from my previous question, you mentioned I should declare a relationship with Centrelink if our 300 PB. Does that apply still even though our relationship isn't registered? As far as I'm aware, you can't register your relationship as de facto if you've applied for a prospective marriage visa. This depends on what we're talking about here. I can't comment in terms of the relationship definitions that Centrelink allow you to register, okay? So we don't deal with Centrelink. We deal with the Department of Home Affairs, the Migration Act, and the migration regulations, and the legal definitions that are found in those pieces of legislation. In terms of Centrelink, what needs to be registered, you have to have a conversation with them directly. My answer around declaring a relationship with Centrelink if you've applied for a PMV is that if Centrelink allow you to register and to report the relationship, that's only going to be beneficial to your PMV application because it's part of your relationship evidence. In terms of your question, can you register as de facto if you apply for a PMV? I know why you're asking that question. It's a misconstrued requirement that you can't be in a de facto relationship if you've applied for a prospective marriage visa. That's not how the law works. Specifically, that's in relation to people who are overseas and are trying to apply for a prospective marriage visa and then are claiming that they're in a de facto relationship with somebody else. That's when complications can arise. It's not in this scenario where, let's put it this way. If you're applying for a prospective marriage visa and the Australian partner's here, you can register the relationship as a civil union. That's not going to jeopardize a prospective marriage visa. Couples that are applying for prospective marriage visas can be in de facto relationships. And in fact, the department are saying that the only prospective marriage visa cases that they are approving at the moment, because the borders are closed, are those that are in de facto relationships. So if you have a PMV pending and you can prove that your relationship is now de facto, you let them know, you forward that de facto evidence, and they're saying that those are the types of PMVs that are being approved at the moment, because it's those couples that can then get travel exemptions, because you need to be de facto for the travel exemption. So even if you get the PMV approved, you also need the travel exemption, which means you need to be de facto. So all that being said, there's no problem in you registering the relationship with Centrelink as long as they allow you, and as long as that doesn't have implications to your Centrelink payments that you're not willing to cop. the rest is fine. The rest is okay. Okay, guys, we'll go for a few more minutes. I'll finish up at 8 p.m. Brisbane time. I want to ask about overseas police certificates for partner visa. If you've already submitted it to your partner visa application and is more than 1.5 years and I didn't travel overseas, will it expire or should I get another one? If you haven't been back since the date of the certificate, then you should not be required to provide another overseas police clearance because logically you haven't been back to commit a crime. Okay, so therefore the previous certificate, even though it's over 12 months old, is still an up-to-date reflection of your criminal history there or lack of criminal history in that country. Okay, so to summarize, if people are applying for partner visas and they have old police clearances from back home, as long as they haven't been back home since receiving those police clearances, there should be no need for you to get new ones. If you get a request for a new police clearance from that country and you haven't been back since getting the last one, let the case officer know, bring it to their attention. They may have just misread or misunderstood your travel dates and your periods of stay in countries or visiting countries. So yes, shouldn't be any need for you to get another one. Okay, guys, I'll answer a couple more. Barun, hi man, I'm a sponsor. I've been in Australia for around 7 years and 2 years in India for studies. Do I have to get police clearance certificates from India for the period of stay? I don't know if you would know. If yes, do you know how I can get an Indian police clearance? Barun, you will need police clearances, Australian federal police clearances and clearances from any country you've been in for 12 months or more in the last 10 years. So yes, you will need them. How do you get them? I can't give you a breakdown verbally. The easiest way to describe that is go to Google and type in police clearances Salvo migration, and you should find a blog that we have that breaks down the step-by-step process of getting a clearance from any country. But basically all you need to do is you need to go to the department website to a certain area and it'll explain how to get clearances from each country. But the blog will explain it, okay? So Salvo migration, police clearances, Google should find you that blog. Next question, one or two more. What are the chances of getting a partner visa after overstaying? I suppose there's a long answer and there's a short answer. The long answer is that if you are unlawfully in the country, illegally in the country because you've overstayed a previous visa and now you're trying to apply for a partner visa, you need to satisfy Schedule 3 requirements, which you won't, which means you need to get a waiver of Schedule 3. That's where you need to show compelling and compassionate circumstances. I've spoken about this tonight. There's videos on our YouTube channel where I talk about Schedule 3. The short answer is that the chances are reduced, okay? Because it's very difficult to show compelling and compassionate circumstances, especially if someone's overstayed intentionally. Because the government don't want to make it easy for someone to rectify their visa status or immigration status in the country if they have intentionally overstayed and tried to circumvent the visa mechanisms and circumvent visa options to Australia, stay unlawfully, find an Australian, have children, and then apply for partner visas. They don't like that, okay? So what are the chances? Lower? Impossible? No. Nothing is impossible. Some things, but not in this context, but certainly much harder. Okay, guys, one more question. Martin, if I'm married to an Australian and have a visa, do I need a travel exemption? Yes. So if you're married to an Australian and you have a visa to enter the country, okay, the visa is one thing you need to enter, but you also need a travel exemption. To get the travel exemption, you need to prove your relationship to your partner, to your spouse, to your married partner. So you treat it like like a partner visa. It's like a mini partner visa, proving the relationship in order to get the travel exemption. You already have the visitor visa, so that part's done, or the visa, that part's done. Now it's the travel exemption. There's a video on our YouTube channel. It's called Visa Options for COVID-Affected Partners. I talk about the different scenarios and the process of applying for a travel exemption, so hopefully that will help. Okay, everybody, thank you very much for attending this evening. Like I said, we were trialing a new system where we were streaming simultaneously to multiple platforms. So I'd be interested to see where all of you have come from. There are links around this video where you can find some more resources that we have for people that are looking for a little bit more help with their partner visas. A combination of free and paid resources that we make available. For couples that want to know a bit more about us as an agency, why we can help them secure their partner visa, there's a link around this video to our partner visa approvals booklet. In that booklet, you'll find over 50 partner visa approvals. That slide says 40 because that slide's out of date. The booklet now has 50. So have a look at the approvals, have a look at the testimonials. And if you're interested in us taking over or handling your case, there should be a link to leave an inquiry. Okay, leave an online inquiry and we'll get back to you as quickly as we can. So thanks again, everyone. And I will be back on same time next week for another live Q&A. I hope everyone has a lovely evening and a wonderful weekend.